Hello, welcome once again to the Law Professor channel where we discuss various aspects of law. In this presentation, we shall be looking at cost of employment, the meaning of cost of employment for the purposes of determining whether an employer, a master is vicariously liable for the tort of his servant. And this helps to situate issues when you are trying to make someone responsible for the tort of another person. In our usual manner, we will state that our presentation today has some learning outcomes. It has some learning outcomes. And what are these learning outcomes? The learning outcomes are to be able, at the end of the day, to define and explain the meaning of cause of employment for the purposes of vicarious liability, to understand the meaning of salmon test, which we'll be referring to in terms of explaining the meaning of cause of employment, and to understand the rules of vicarious liability, where there are some prohibitions, where there is a deviation, where there is improper delegation, and so there are other components of issues that could arise when considerations are given to whether somebody was acting in the course of their employment. Now, it's usually said that someone is in the course of their employment where the employee or the servant's conduct is authorized by the employer. If the conduct is expressly authorized by the employer and that conduct constitutes a tort, for instance, then the employer will be liable. Or if the employee could be said to be expressly in the course of his employment, you've employed this person as a driver. He is supposed to drive students to the university and back home every day. He was doing exactly that. We say he's in the course of his employment. Or you have employed him, you told him to dig a pit on a piece of land. He was digging the pit on a piece of land. It turns out that that digging of pit is a trespass to that land. The employer will be liable for the employee's actions in the course of employment. Also, a master is liable for acts which he has not authorized, provided that they are connected with acts which he has authorized, that they may be rightly regarded as modes, although improper modes of doing them. He has not authorized the act, but the employee was performing an authorized act, and it is said that he performed the authorized act in an unauthorized manner, and we call this the salmon test. He was not authorized to do the act, but the things that he has done are connected. We talk about the close connection test, and this aspect of the salmon test will be used especially with regards to vicarious liability for criminal conduct in subsequent presentations, or where the act is incidental to the authorized acts. In any of these situations, a servant is said to be in the course of employment. How do these play out in practice? Let's look at them, individually. Where you have expressly authorized an act, like I said earlier, that is very clear. If I've told my servant, my employee, to do something which constitutes a wrong, then I would be held to be vicariously liable for that wrong. And that would just be it. The other aspect is where you have an unauthorized mode of doing authorized act. The act is authorized. The activity that the servant has engaged in, for instance, the servant that is driving a car, the doctor that is performing a surgery, a lecturer that is teaching students or marking scripts, the bank manager, the cashier that is handling customers' money at work during the working hours. They are doing what they have been authorized to do. But maybe the way they did it was not authorized. Their manner of doing the work was not authorized, and it is that manner that has constituted a wrong. The law is that the master is still vicariously liable for this wrong. And you have this line of cases where maybe driver was doing you have driving, and because of driving, they did something wrong. One smoked at a filling station, and it led to a blaze that burnt down the filling station and other property. Yes, the employer could say it was not authorized to be smoking on duty, maybe has even been prohibited, but it was delivering the fuel in which he was employed to do, even though he did the delivery in a manner that he was not authorized to deliver. So in such circumstances, the courts have held that the employer will be vicariously liable. Or if somebody is driving and is over speeding, I say, oh, it was not employed to overspeed. Nobody employs anybody to overspeed anyway, So in such cases, the employer will remain vicariously liable because the courts have held that these are instances where the mode of doing the work was what was wrong, was still doing its authorized acts in a manner that was not, authorized by the employer. Then there are situations where there is a willful disobedience by the employee, by the servant, where the employer probably had envisaged the risk areas, the risk factors in an employment, and had warned the employee not to engage in such activities. Would such employer now argue that because I have prohibited him, I've warned him, I've told him not to do that which he did, I will not be liable? So you have prohibited conduct and improper delegations in these cases of disobedience. With regard to prohibited conduct, an employer who raises the fact that he has prohibited the employee from doing certain factors would have to demonstrate to the court the nature of the prohibition. Is it a prohibition that limits this employment or a prohibition that limits conduct in the course of employment? Where you, for instance, you employ somebody as 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 a cleaner, he's not allowed to be your driver to drive. So if he goes ahead and takes the company car and drives, is a prohibition which limits the scope of his employment. His scope of employment is cleaning. It is completely different from driving. The employer cannot be vicariously liable for that. That person was not working in the course of employment, unless there's evidence of express instruction for him to do that. Well, but where he has been prohibited, where an employer is able, or a master is able to demonstrate that the prohibitions limit scope of employment, that employer will escape vicarious liability. But where a prohibition limits conduct, what you can do while you are being employed, okay, what you can do, what activities you can engage in, where the employee disobeys those instructions, the employer cannot escape liability. The employer remains vicariously liable if he has been told, and the usual cases are cases like drivers who don't overspeed, don't overtake, don't do competition. Sometimes you see them running, trying to get passengers ahead of each other, all sorts of activities, and they've been told by the employer not to do. Don't um, don't drive without seat belts, don't do this or that. These are just prohibitions that regulate your actions while you are involved in your employment. So if a driver has been told not to exceed 70 kilometers per hour and he does that, not to overspeed, not to overtake, not to race with other passengers, and he does that, those are prohibitions that will not make the employer to escape liability. The employer cannot escape liability. He would remain vicariously liable. I can see the case of Nimbus and London General Nimbus Company, Twine and Beans Express Limited. So the case of Twine and Beans Express Limited, Jamakani had transport against Abeke, and these are cases that dealt with prohibitions against carrying of passengers. And the position of the court has been that where such passenger, for instance, gets injured in the course of the journey, against express prohibition not to be carrying passengers, that that passenger is that employee is actually working outside the scope of his employment, that those prohibitions are prohibitions that would enable the employer to escape liability, seeing the passenger as a mere trespasser, so to say. Now, the statement of Lord Green in Twine and Beans Express is explicit. It says giving of lifts to unauthorized passengers is not merely a wrong mode of performing your act or the class the driver was employed to perform, but the performance of an act of a class which he was not employed to perform at all. I tell you that sometimes these petitions are actually policy reasons because cannot actually logically explain the difference in treatment in this, except to say that, well, if you are trespassing on my property or my, on my premises, that is the vehicle, why should I now be responsible for the consequences of your trespass, so to say? So giving of lift is seen as an action outside the course of employment of the employee. And then you have rules about delegation, where employees have been warned also not to delegate their responsibilities, not to allow somebody else to drive the vehicle, for instance, not to allow the driver. Sometimes it's even the conductor. A conductor is not employed to drive in an organized society. So if you go and delegate, maybe you're a medical doctor, you go and delegate performance of your work to someone else, even a co-employee, it may raise issues about whether the delegation was proper or not. And when these instructions are quite clear that you are not allowed to delegate, you're not allowed to make others do your work, and you do that, and that other, in the course of doing that work, causes an injury to a third party, it is possible that the employer would escape liability. The case of Ikwe against Samuels is illustrative of that point. It is quite possible. But there's also another form of argument that says that, well, the employer may not be liable vicariously for the act of a third party, which now causes injuries to the plaintiff. But the employer may be liable for the fact that the employee delegated. The improper act of delegation itself is an act for which the employer could be liable. Then you have acts that are incidental. We said in terms of vicarious liability and in course of employment, if the act is expressly authorized by the employer, if it is an unauthorized mode of doing an authorized act, the salmon test that we are talking about, or if it is incidental to the act that he was employed to do. There are some things that your employer may not have employed you to do, but they are regarded as incidental. The employer, for instance, does not employ you to be. I'm a lecturer, for instance, and the terms of my employment are well stated. I'm not to secure the property of of my employer. I'm not supposed to be, to do anything in that regard. But assuming that I see someone trying to steal the property of my employer, a good employee would also do something to protect that property. If the property of the employer is on fire, I cannot say I'm not employed as a firefighter. You will still do some things that are incidental, that are, a natural part of your employment that can flow. So some acts are regarded as incidental. And in Poland and Jumper and Sons, for instance, the court said that the defense of an employer's property is incidental to the act of employment. That so that where there is a wrong committed in the course of defending or protecting your employer's property, then you would be able to make the employer rigorously liable. Sometimes employees, and this applies to companies who employ drivers or private persons who have drivers working for them especially. And you have situations where these people, ordinarily, if you employ a driver and you give instructions, okay, for instance, a driver that is employed by company A is supposed to be driving the staff bus and taking staff from their place of abode to the place of work. That is what is employed to do. And it can be sent on an errand, or a private person with a private driver. If I say, take my children to school, drop my parents in their home, go and do this for me, go and get some groceries. You give them express instructions when they are going to do anything for you. If the driver decides to go against the instructions, it goes on the route that he's supposed to fly and goes on his own purpose, the employer may not be like vicariously. So when you have deviations or detours by employees, it has been said in Story and Ashton and Joel and Morrison that it is a question of the degree and how far the deviation could be considered a separate journey, where a driver leaves the route that he was supposed to take to deliver the errand, the message he has been sent, and deviates. The degree of deviation, how far away you went. For instance, someone is sent from Akoka to Victoria Island in Lagos, and he leaves Akoka and faces Ikeja or Agege to see a friend. And in Agege, he runs into another vehicle and causes damage. The degree of detour is so great. that he can say it is a separate journey that could divest the employer of responsibility. But if the degree is not great, so he was supposed to go to Victoria Island, he's supposed ordinarily to take a particular route. When he got to Third Mainland Bridge, instead of him to take to go straight down and take, maybe he wanted to take, he was supposed to take Ikoyi to enter VI, decided to go through Lagos Island to enter VI for whatever reasons. Assuming there was traffic, or even if there was no traffic, maybe to pick something along the route and still, it may not necessarily be a separate journey. It may still be possible to hold the employer liable. Or maybe it was because of traffic that he deviated so far. So it may be a long deviation that he even went through Ikeja to get there because the road through the normal route was blocked. So in this respect, the facts of the case will determine the purpose or the deviation, the degree of deviation, the extent, and that will now determine whether we can say this is a completely separate journey. This is not what you were employed to do, and you are on your own journey. You are on a frolic. And when a driver is said to be on a frolic, when an employee, a servant is said to be on a frolic, we are saying he's doing his own business, cannot make his employer to be vicariously liable. So you see Story and Hardstein and Joel and Morrison for that purpose, and also these lines of cases which dealt with forms of deviation. Williams and Enfield Limited, for instance, where the employer's children requested that he stop somewhere else in the course of taking them to the authorized route. The court said that deviation was not a substantial one and that deviating to please the children does not take him outside the course of his employment. And the employer was liable vicariously for the act that's occurred. Now, there are some situations where, when you say course of employment, if somebody is driving your car, can we say the person is your servant? Or is he on his own? Again, the general presumption, the starting point is to presume that when somebody is driving your car, is your agent at the time in question. I can still me you are additional and care for that purpose. The person driving your car is presumed to be your agent, such that if anything happens on the course of him using that car, you will be held vicariously liable. In fact, you could be, you may even say it's not vicarious liability, that you are primarily liable, but the first is still vicarious liability. Now, it is incumbent on the owner of the vehicle to report this presumption and show that this person was driving my vehicle, but he was not my agent. If a wife is driving the husband's vehicle, now registering the husband's name, the presumption is that she is the agent of the husband. So if she's going to do school run, for instance, and she has an accident on the road, because it is caused by the vehicle owner, the vehicle is one that can be impounded. His vehicle is one that has been involved in a road traffic offense or whatever it constitutes or it ought. So the owner of the vehicle is generally liable. But the burden is on the owner now to say, this woman, though she's driving my vehicle, is not working for me, is not doing my business, that is. Okay, so in order to show that it's not just to say, because I allowed you to drive, then you are my business. No, it must be that you are doing it for my purpose. Sure, you are doing something for my purpose. So if this happens, you look at the facts of this case. For instance, people are getting married, they get vehicles from people to use their cars. If anything happens in the course of that ceremony, with the vehicle, causing damage or injury to a third party, these presumptions will begin to operate and then begin to dispute them as to who should be responsible. So some of the working presumptions are these: that a servant is presumed to be working for the general employer. Once somebody is established, for instance, Mr. Hay works for company ABC and is driving company ABC's vehicle, the law will presume that Mr. Hay is in the course of his employment. It is for the ABC company to come and show that this servant of ours was not working in the course of employment. So employee is presumed to be working in the course of his employment. Where there are two employers, the employee is presumed to be working for the general employer, the one that employed him initially. For instance, a security unit which sends security men to various companies. The security man gets to the company that he is seconded to and commits a wrong in that company and is being sued. The security company is presumed to be vicariously liable. It is presumed that that security man is still working for the security company. Let the security company come and show otherwise. An agent is presumed to be working for the benefit of the principal. If I'm driving my husband's car, it is presumed that I'm working in his favor for his benefit, such that he can be held vicariously liable as I can for as being my principal. Again, these are working presumptions. It can now be demonstrated in evidence that I was on my own business. Then a a servant who is in the course of his employer, who is working in the course of duty, is presumed to be in the line of business. If you want to say your driver is on a frolic, you must come and prove it. Once the person is a private driver, the law will presume that he's working for you at the marital time that he was driving your car. If he has closed for the day and he's going home, he's no longer working for you. So we must also get those contexts correctly. So in those situations, these presumptions would work, and it is left for you to disprove it. At the end of the day, we must understand the fact that in vicarious liability, it is incumbent for you to prove that the servant is working in the course of his employment. It's not sufficient to say that the person is a servant. It's not sufficient for you to say that the tort has been committed, but you must also prove that this tort was committed in the course of the employment of the servant. And course of employment has been defined in three ways: where the act is especially authorized, or where it is an unauthorized mode of doing an authorized act, or where it is incidental to the act which the servant is employed to do. And then where a servant deviates from the authorized rules, you need to consider the circumstances of the case. Why was he deviating? Where was he going on this deviation? What is the extent, the scope, the degree? And if it is found that it is completely a separate journey, they will be said to be on a frolic, and the servant, the employer will not be vicariously liable. Where there are prohibitions, whether the employer will be vicariously liable will depend on the nature of the prohibition. Where a prohibition limits the scope of employment, the employer will not be vicariously liable. You are being employed as a driver. You are not employed as a cook. You are employed as a doctor. You are not employed as an anesthetics. You are employed as a dentist. You are not employed to administer drugs. These are some of the ways you say scope of your employment must be clear. But where the prohibition leads to conduct in the course of employment, when you are a doctor, these are the things you can do within the preferences of the doctor's work. As a driver, these are the do's and the don'ts. If you flout such prohibitions, they are regarded as prohibitions that limit conduct in the course of employment. You still continue to be liable as an employer for the flouting of the order. Where an employee makes an improper delegation of duty, the general rule is that the employer is not vicariously liable for the act of the delegate. These reported presumptions have been interpreted by some cases in the law. At the end of the day, we must continue that we must be able to conclude that this servant was actually on the business of the employer, because you remember the premise upon which vicarious liability is said to arise. Okay, so once you conclude that is in the course of employment, then you would have established the third and most important one of the components of the principle of vicarious liability. And don't forget that this relates to vicarious liability for the tort of a servant. In the next presentation, we shall be looking at another segment of vicarious liability in tort. Don't forget to like the video, subscribe to the channel, and also share. Thank you.